All right, we are doing something somewhat risky today. Oh my gosh. Okay, this is going to be something of a sequel to the Viva on Ice talkie vlogs. This is Viva on Ice, but it's melted ice. Okay, so I'm gonna fish today and talk about the recent Second Amendment judgment coming out of California from a federal court judge, Benitez. First of all, I'm fishing with a Canadian flag, Len Thompson lure. I've got my pliers. I don't have gloves or a net. I'm really not expecting to catch anything, but you never know. Wait until you see the setup. I am using an old cross-country ski boot holder, duct tape to a paddle boat, but it's stable enough to do a vlog. So let's get into it. It is Miller versus Bonta. And this is a constitutional challenge of 3 decades old piece of legislation out of California that banned assault rifles. That's how they talk about it in the law and in the judgment. But basically, I don't understand the logistics of it. I just know what I read in the decision. It bans certain features on firearms, which are deemed to be assault rifle features. The legislation has been in effect for 30 years. It had not been challenged apparently until now, and a federal court judge has declared that the legislation is unconstitutional and infringes on Second Amendment rights guaranteed by the Constitution because it is overly broad, effectively bans firearms that are available in other states and other jurisdictions, and penalizes otherwise lawful owners in violation of Second Amendment rights. Now, first question everyone should be asking, Judge Benitez was appointed by George W. Bush. So for anyone who wants to write off the decision as partisan whatever, that's your out. The decision itself, 94 pages long, very long. I skimmed through it, but I read it, and it's well-reasoned, goes through facts, statistics, which we're going to get into. But it starts off with an analogy. And for anyone who has been around this channel for long enough, you know that I'm not a fan of analogies because analogies are not useful when discussing a specific issue. You don't need an imperfect analogy when you have a perfect case, which is the issue at hand. The other reason is that analogies are fundamentally analogies, therefore imperfect. They will never be perfect. And when you use analogies, you give people a way to confuse the debate and get distracted on secondary issues that are not related to the issue itself. Not only does the judge use the analogy of comparing the firearms at issue to a Swiss Army knife, he does it in the intro paragraph. So I believe this was not a strategic mistake. I believe this was deliberate. He uses it in the introductory paragraph to compare the firearms at issue to a Swiss Army knife, which is sort of like an all-in-one pocket knife that people like for that very reason. Using that analogy, you knew you were going to get some reactions, and reactions it got. If you go look up this decision or reporting on this anywhere in mainstream media, this is the first thing they're talking about. Gavin Newsom came out with a public statement saying that the analogy, the comparison is a slap in the face of people who have been victims of firearm violence. Politics is what it is, and you know that people who disagree with this decision are going to try to find ways to go after it. The decision itself is interesting because it's well-reasoned, it's lengthy, it's verbose, but it gets into the statistics and the history pretty early on. And at one point in the decision, it refers to the legislation at issue as a failed experiment. And 14,000 pages of evidence, by the way, were filed in the context of this decision. The judge specifies that he's only going over the most salient of that evidence, but gets into statistics as relates to the specific types of firearms at issue, the features that they have, which were outlawed. And he's basically said, like, statistically, the legislation is difficult to justify because he compared it to knife violence, hand violence, and said that the specific types of firearms that were targeted by this legislation, it couldn't be justified by the statistics in his humble opinion. So it's an interesting thing. It's apparently, I'm not full into this stuff. I don't understand the distinction, the discussion about the features, but I'm not much into the law either because I'm Canadian, and Second Amendment rights and Second Amendment discussion out here doesn't exist, and doesn't exist to the same extent it exists in the United States. There is a giant heron right over there. I can't turn the camera around fast enough. Maybe if I go like this and then do it slowly, hold on. It's gonna be gone by the time we get there. All right, so you didn't get to see the heron, but bottom line, the judge struck down the law as unconstitutional, not supported by the statistics, and that's not the end of it though, because although he declared the law unconstitutional, at the end of the judgment, he stays his own order for 30 days, pending California's ability to appeal the decision, to petition for a longer stay pending appeal. But if the state does nothing, and it won't do nothing, it's going to do something. But if the state does nothing, in theory, the declaration of unconstitutionality and the order itself and the law itself becomes unenforceable after 30 days, which happens to be, the order was rendered on June 4th, 30 days, if nothing were to be done, would be the 4th of July. Also, probably not an accident. But, so that's it. So there's a 30-day stay on the decision itself, because they go through the criteria of issuing a stay, serious issue on the merits, likelihood to succeed on the merits, and the judge says, although it doesn't need to be certainty to succeed on the merits, because the judge is basically not rendering a decision that he thinks is not going to be upheld on the merits. He says the possibility or the probability that it could be overturned on the merits could warrant a stay, and so he issued a 30-day stay, which is set to expire on the 4th of July if the state does nothing, but the state is probably going to do something. We will be discussing this with Robert Barnes tomorrow night during the live stream. For those of you who don't know, Robert Barnes, world famous attorney. We do a live stream every Sunday. We do the sidebars every Wednesday with guests, and we've got some good guests coming up, so stay tuned. And that is it. If you like my videos, please be sure to like, share, subscribe, hit the notification bell. If you're subscribed and you haven't hit the notification bell, it defeats the purpose of subscribing. But go ahead and do all that if you want. If you don't, you can watch me fish for another 5 minutes and see if I can catch anything. And you know what? The wind is actually blowing me very far away from shore. We had a weather warning in effect for this part of Quebec. Tornado warning. So I'm on the lookout for tornadoes and thunder showers, but so far so good. Although I'd better start paddling back to shore because this thing doesn't move fast. And if the wind is strong, the wind can move me faster than I can paddle with my legs. Peace.